Hello and welcome to our Facebook Live and in-person free seminar on the Divorce Navigator Workshop. We are in session 3, and today is going to be sort of intense because we're talking about identifying and preparing documents and witnesses, your evidence. How do you determine what your evidence is in a family court case? And then once you determine what it is and what it should be, how do you use it? How do you introduce evidence? How do you organize it? So we may find that going forward, we want this session to be 2 sessions, and maybe our 11-part series turns into 12 parts. That's kind of what I'm thinking, but I definitely could use your feedback. Also, as always, we're open for whatever questions that you have, and there will be a free flow of questions and answers at the end of the seminar. We've set aside about 30 minutes for information and then about 30 minutes for questions and answers. I already have some that have been written in. If you want to send in your questions and you don't want to type them on Facebook, you can text them over to Caitlin. You can text 480-649-2905, and Caitlin will go ahead and put that in the comments now, right? Nice, she already did. Also, you will see from the comments as well that this is not legal advice, just information so that you can be as empowered as possible moving forward. All right, so today, preparing information for determining what is your evidence. We're going to talk about disclosure, discovery, the rules of evidence, what to look for, what's required in your case, using witnesses, how to identify witnesses, when you might need an expert, when you might not need an expert, how to file documents. Logan? Okay, so can everybody out there on Facebook hear me and see me? Just give a little shout out, say hey. You can test it, Caitlin.
I just was trying to get that fixed.
Got you. Okay. So in the next session, say we're doing preparing and identifying evidence. Next, we'll do pre-hearing conferences, which are like your RMCs and your ERCs and return hearings. And they have so many words. So we're going to go through all of those, what those mean, and how to prepare for those. Divorce negotiations, which are always required. Things like ADRs or mediations, alternative dispute resolutions. Some form of mediation is usually always required. So we'll go over that. And then trial preparation and presentation. So the first half of our series is really focused on the procedure and how to get through it from start to finish. And the second half of the series is really focused on the substantive meaty portions of the law. We talk.
The screen isn't sharing, that's
That's
what.
happening. You want to come fix it? Caitlin's going to come fix it.
Okay, sorry.
All right, thanks. No problem. So the second half of the series will be all about more of the substantive pieces of the law, and we'll go into all of the different issues that surround divorce and what it means, like when can you get sole custody, that sort of thing. Child support, spousal maintenance, custody issues, and property concerns. So with that, today is really when you start thinking like a divorce attorney. We're going to get much more analytical. Previously, we've been really practical, how to hire an attorney and how to know how much to spend. And now we're going to really start analyzing your case through the lenses of an attorney. Information is evidence. So let's start here. And this is a little difficult, so bear with me. You have to offer evidence to the judge for every element of every issue relevant to your case. Now, those are a lot of lawyer words, so I want to break it down. Let's take child support as an example. So we talked last week and the week before about animal issues from the broadest level, our kiddo issues like legal decision making and parenting time and child support, and then other divorce issues like property division, spousal maintenance, and then some other related things. But those are the broad level, highest level 5 issues that you could face in your case. Now, if we take child support as an example, child support is the easiest one to demonstrate because it's pretty straightforward. There's a calculator. The calculator has inputs. So we're going to call those inputs the elements, okay? So in order to determine child support, you have to have, actually, maybe this isn't the best slide for this. Yeah, here. So we talked about all the issues. Here's where we're talking about child support. Now we're going to talk about the inputs that go into the calculator, okay? So in order to calculate child support, we have to know mom's income, dad's income, kids' birthdays, the parenting time arrangement, health insurance, costs for the kids and who provides it. So for instance, if mom has health insurance and the whole family is covered and it costs $1,000, you have to find out what portion of that is specific to the kids. We need that information to go into the calculator. Childcare, if there's any, how much it is, who pays for it, and any extra expenses for the kids. Those inputs into the child support calculator are elements. So we have to offer the judge information on each of those elements that he or she needs in order to figure out child support. That same analysis is true for all of the other issues as well. If we were talking about parenting time and legal decision making, we would go to the statute, and the statute has 13 factors, and any of those relevant 13 factors, we'd have to offer evidence to support your position on it. This sounds so formulaic and so frustrating because you as a client just want to get up there and tell your story and then have the judge figure it out. Well, that's not how it works. And the whole point of this series is to set you up so that if you're representing yourself, you can be most effective. And that means playing by the rules of the system that you're in, okay? So if you want to talk about, how awful your ex-husband's current girlfriend is, you got to figure out a factor under the parenting time statute to talk about it in, okay? So that is more when we get to the law, but this is why this section is so difficult. So, if you trust me, then you know that you have to give evidence to the judge of each of these elements of child support. How do you do that? You do that through a number of ways. Witness testimony, which can be your testimony or the other party's testimony or any other witnesses that you're bringing to court, or documents, or both, okay? So the easiest way to do this, some of the things will not be disputed. If you're using an affidavit of financial information, that will have almost all of this information on it. And you can use this when you're presenting your evidence. You can say, Judge, here are the kids' birthdays, how much money I make, here's his affidavit of financial information, here's how much money he makes, here's a receipt for how much we pay for health insurance and childcare. There you go. At that point, you've covered each element. But a judge can't make a decision or do a child support worksheet without you providing each element of information through either your testimony or documents or someone else's testimony. Okay? Does that make sense?
Yep.
Okay, great. Now, let's talk for a minute about the rules of evidence. The rules of evidence governs what comes into evidence, what a court may look at, and what a court can't look at. You've probably heard objection, that's hearsay, or lack of foundation. You may have heard these terms, which are lawyer objections, evidentiary objections. In family court, in general, the rules of evidence are relaxed, and anything can get into court that is relevant. That is always true. Okay, unless someone files a notice of strict compliance. Most of the time, people who are representing themselves are not going to be filing a notice of strict compliance. But if you are representing yourself or if you have an attorney and you're just looking to get more information, and your other side has an attorney, they may file a notice of strict compliance. That means that the rules of evidence have to be followed. Sorry, I have a cold. I'm trying to knock off. That is not always true for kiddo issues, okay? Because there's a case in Arizona, Hayes v. Gamma, that says if there is evidence that is related to the best interest of the child, then we don't care if it follows the rules of evidence it's getting in, because it's more important to get it right than it is to follow the rules on the issue of kiddos and best interest. But in general, anything that is relevant to any of the issues will get in. Now that's important because you're going to go through and look at every issue that's relevant to you, and you're going to map out the elements or the subparts that must be proven under them. And then you're going to look at all of your evidence, and you're going to determine, where does this piece of evidence go? Under where in the outline of the issues and elements can I talk about my ex-husband's new girlfriend's crappy dog that bites people? You can probably do it. You can probably do it. But you have to do it within the context of your outline that you're going to create, okay? All right. Now, how should you organize all of your information? We recommend you do it this way. You'll have one folder for all of your pleadings and your orders. Orders are things that come from the courts. They're minute entries, they're rulings from a judge. Anything that's ever happened in your case should be in one pile, probably in a folder, either an electronic folder or a paper folder, whatever you prefer. And then all of the pleadings. Pleadings are anything that's been filed with the court. You want all of this, probably. You definitely want to start thinking about this as you put it together. And then there's correspondence with the other side. Let's see. Can you grab one of the Decode Your Divorce books?
Yep.
Okay, great. I just want to show them that in a minute. Correspondence with the other side, so emails back and forth that you wrote where, she said that she refuses to come meet you at the designated drop-off spot because she's too drunk to drive. You may want that. So put that in the correspondence folder. Keep that together. Don't print out or save every single communication that you have with your ex about anything that may or may not be relevant. But if you've got things like where, mom's saying she's too drunk to drive, you're kind of want that. And then disclosures. And the reason I asked Caitlin to go grab this book is because disclosures is a complicated word. It doesn't make any sense, right? It's not like how normal people speak. But Rule 49 of the Arizona Rules of Family Law Procedure lets you know what you must disclose. Those disclosures are not optional. They are required in every case. You and your spouse have to exchange information as required by Rule 49. Now, even though I've been doing this for a long time and wrote a book on it, I can't remember everything that's in Rule 49. So if you go to the Decode Your Divorce book and you go to the table of contents, is super nifty because it'll tell you exactly where to go for everything. Page 59 is all about disclosure and discovery. And it is a fantastic sheet to tell us what you have to disclose, okay? And it's broken down in the same way. So depending on your issues, corresponds what you must disclose, okay? So it says if you have property issues, you must disclose deeds, that sort of thing. If you have kiddo issues, you must disclose this, that sort of thing. So you must do it. You have to go to Rule 49. You have to figure out what you need to disclose. It's all of your financial information. It's statements. And you are supposed to make these exchanges of information within 40 days of the response being filed. In all reality, this doesn't always happen, especially with people who are representing themselves. And sometimes it's overkill. Sometimes you don't need that. You and your spouse, you agree on enough things so that it's not mandatory. So this section, this disclosure and discovery section, is really when you're litigating. You're not necessarily getting along. You're not necessarily working cooperatively. And now you've got to follow the court rules. And that's why it can be so confusing. Witness testimony can make or break a case, for sure. And we do witness prep with our clients for that very reason, where we go over with them how to be the best witness they can, because you have one chance to make a first impression. Anyone can be a witness if you have personal knowledge of the situation, okay? An expert witness is someone who doesn't have personal knowledge of the situation, but who's offering opinion based on the facts that they've been given so far, all right? So who can be an expert witness? You have to be qualified to be an expert witness. You have to have enough information and experience and training to be an expert. So if your mom wants to testify about how she's pretty sure that, I don't know, the daycare provider is a lousy daycare provider because she's not licensed, and in her opinion, if you're not licensed, then you're not an adequate daycare provider. Let's use the test. Does she have personal knowledge or information? Not if she doesn't know the daycare provider and she hasn't seen the daycare provider. So she's only available as an expert witness. If you don't have personal information, you can't be a witness. You have to be an expert witness. And can she be an expert? Well, I don't know. I mean, unless your mom is a daycare expert, no, she probably can't. So you need to object, right? Because that witness is not qualified to offer that information. And most of the time, people don't take the time to think through the logistics of these things. If somebody is on the witness stand and they're testifying about things that they have no personal knowledge about, object. You can object, even if you're not an attorney. You can object. So do it. You weren't there. You don't know.
Do you have to you just say object, or do you have to follow that up with something?
That is a great question, Caitlin. You stand up. First of all, it's difficult if no one's represented, then you don't really have questions and answers. So typically, if you were following the rules, the attorney would finish the question, and then you could stand up and say objection. You have to state your objection. So yeah, I would follow up with this witness has no personal knowledge, or beyond the scope of what they're capable to talk about. Qualify. You just say yeah, totally.
I'm just curious how
it's pretty
not represented.
Right. Exactly. Yeah. That's a good question. And we fight all the time about who's an expert. Again, because the rules are pretty relaxed. If someone's arguably an expert, the judge is probably going to let them testify. But you are allowed, a lot of people have parenting coordinators or other people, counselors, come testify. And a counselor is an expert at some things, but not necessarily other things. And so if you have a counselor that is testifying against you, making all sorts of statements and opinions about you, they've never met you, and they're not qualified because they're a counselor. Let's say there's some counselor who says, I think based on what dad told me that mom has bipolar disorder. You can object. First of all, they have no personal knowledge. They've never done an assessment. Second of all, they're not an expert witness and haven't been qualified as an expert witness. So these are just seeds to plant. If you have questions about your particular case, this is something probably worth talking to us about. All right. Parenting expert witnesses are all of these things: parenting coordinators, court-appointed advisors, forensic psychologists, financial experts. You may need an expert if there is a real difficult issue, a complex issue. Let's say there's a business valuation, or you're fighting over how you think that your ex-spouse is underemployed. You think that he should be making $150,000 a year and he's working at Dairy Queen. Then you may want to have a financial analysis of that person to determine what their actual earning capacity is. And instead of you just saying, Judge, he should be making blah, 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 you're not really an expert. So you can testify as to your personal knowledge of, in the past, he's made $150,000, but you can't say he should necessarily, because you're not an expert. But there are experts who do that. And depending on what's at stake, that it may be a good idea for you to do that. Expert witnesses must be disclosed, meaning you must tell the other side who they are and that you intend to use them at least 60 days before trial. So that is why this is section 3 in our 11-part series. You don't just decide at the last minute, here's the evidence I want to use. You start thinking now in the very beginning, what evidence do I need and how am I going to get it? And that's why we're talking about this now. Okay, if you have serious issues, parental alienation, domestic violence, mental illness, if you are trying to overturn previous rulings or get the judge to go in a different direction, these are all reasons to consider using an expert witness. An expert witness is simply someone that you hire to give an expert opinion who has the right training. Okay? This is more about Rule 49. When you don't get what you want from the other side, they haven't followed Rule 49, what do you do? There are all sorts of options and tools that you can use. There are interrogatories, there's a request for production of documents, there's depositions, and there's requests for admissions. But usually you want to start out with just sending a letter and saying, hey, here's Rule 49. Here's what you're required to disclose to me. Here was the date it was due, 40 days past when the response was filed, and I haven't gotten this, this, and this. Can you please give it to me by X date? Put your date in, give it another 2 weeks. This is irritating to people. Sometimes people want their stuff, especially rule followers. They're like, well, why didn't you follow the rules? You're supposed to give it to me. Well, people don't always follow the rules, and you can't just march into court and say he didn't follow the rules or she didn't follow the rules. Follow the process to document why they didn't follow the rules. And that's so important because if you want to eventually recover attorney's fees, you need to show that the other party was unreasonable and didn't follow the rules, and that you were also reasonable and sent letters and gave them lots of opportunities to comply with the rules. Make sense? Strategically speaking, you don't really have an option. You must send a good faith letter that gives people the opportunity to do over or get you these documents. Again, this is why we're doing this now, because the whole process of enforcing disclosure and discovery can take months. Okay? Now, what happens if you don't disclose? It's possible that your documents will not be allowed into evidence. So you could have critical pieces of information that will not be included. The judge could also make adverse assumptions about your evidence, okay? Let's say you don't disclose a bank account, but we know it's there. We could ask, I could say to the judge, Judge, we think there's $50,000 in this account because of X, Y, and Z. And Mom has failed to disclose that account despite repeated attempts. So we are asking that you assume there's $50,000 in there and give it all to us. Because guess what? There's this rule that says if you don't disclose, if you're hiding money, the other side can get all of it, okay? You can't risk this. I've had clients do this. Hiding assets is a bad idea because if you get caught, you had better be willing to pay much more than it would have cost you had you not gotten caught. That makes sense?
Can I clarify?
Yes.
Okay. So if somebody has a bank account and they don't disclose it, but you do find it, do you have to prove that to get the 50,000, or you just tell the judge? And I assume there's this account, but I can't exactly find it. Like sorry.
Yeah, a couple of things. So the judge is allowed to make negative inferences, meaning you don't have to show them. However, if you really want to be ordered a specific amount of money, yeah, you probably need to come up with it.
Okay. But you get everything in that account should you prove it and they didn't disclose
Should
it.
you be able to prove that this information was hidden from you? That is the risk. That is what the statute says. I'm not going to tell you that that's absolutely going to happen, but that is what the statute says.
The judge could order it.
Yes.
Yeah.
And that's the risk.
Mhm.
That's a big risk. Hiding money is a bad idea.
Does that go to property and everything?
Well, what do you mean?
Like assets in general?
Yes, right.
Type,
Not just
a
bank accounts.
account,
Exactly.
but-
Right. Yeah. Stock accounts, houses, businesses, all of it. How do you disclose? This is kind of confusing. So you have to make what's called a disclosure statement. And Rule 49 tells you exactly what the disclosure statement needs to say. Now, a disclosure statement looks a lot like a pleading like a petition or a response or a motion, except for you don't file your disclosure statements. You don't do it. You don't file discovery documents. You create it. It looks just like a pleading. So do you put it in your pleadings folder? Yeah, probably. And it lists out what you gave the other party and on what date. Now, the way we do this and the way that I recommend you do this is you have one disclosure statement per case, okay? So you have one case, you have one disclosure statement, and it's just a long running list of, here's the, your first disclosure is these 10 documents. Now, as time goes on, you're gonna get more and more documents. Just add to it. So then what we do is we just bold the new ones, okay? So I send 10 documents, bank statements, X, Y, and Z, list them all out on this date, send to the other party. You don't have to file it. Next month, you have emails that this person sent you that you want to use. You're going to add them, list them to your disclosure statement, put it in bold, change the title up there to first supplemental. And I don't know that you have to use those words. You could say second disclosure statement or first disclosure statement or third disclosure statement. It's not required that you say, 17th supplemental disclosure statement for petitioner, blah, blah, blah. That's not necessary. But it is necessary that you have a running log of everything you disclosed and the date it was disclosed. And I think it's easier if you have it on one sheet of paper, one document, so you don't have 25 disclosure statements, which sometimes happens, and it's just an inefficient way of dealing with paperwork. Okay, what do you need to include? The names of the documents you're using, your positions on relevant legal issues, which not everybody does, but that's what the rule says that you need to do. So for instance, I think I should have sole legal decision making because my ex-husband is a drug addict and is using heroin. That's a good reason, but you need to put down your reason. You can't just say, I want sole custody because I'm a better parent than he is. Well, you could, but it will backfire. And then you need to include also the names, addresses of witnesses, and a summary of what they will testify to. Because you have a right to know if your ex is going to try to bring his mom in to say that your daycare provider is a bad daycare provider and why. Make sense? And remember, expert witnesses have to be disclosed 60 days in advance. So they've got to be on that disclosure statement, and we need to know who they are and what it is that they're going to say. You don't file these documents, just like you don't file the disclosure statement. You just give them to the other party. The judge will have looked at none of your evidence, zero, before you go into court. And this is something that's really confusing to people. But evidence is only considered if it's properly admitted into evidence during a hearing. And that's what we're talking about. Don't hide something. Don't claim your ex is hiding something. I had a case once where we were pretty sure mom was hiding stuff. We had some good evidence that mom was hiding stuff. And we could show exactly how much income she was hiding. And it was substantial. It was going to make a big difference in the child support calculator. But then we got to court and she asked him on the stand, she asked my client on the stand, isn't it true you got a raise 3 months ago and your affidavit of financial information is out of date and you make more money than this, so your child support numbers would be different? And he had to say yes. And we lost thousands of dollars that we could prove should have gone into her income on the child support calculator because he didn't update his affidavit of financial information and disclose to me and the court that he'd gotten a raise. It was a bummer, but it was a good lesson. Learn from my client, who is still probably paying hundreds of dollars more each month than he would have had he just disclosed a raise that wouldn't have made a difference. Okay, it's a good story. Your affidavit of financial information, which I've talked about a little bit throughout this, is probably the most important document that you will file if you have a spousal maintenance issue. Without a doubt, if you have a spousal maintenance issue, this is your most important document. But it's pretty important for child support as well, and it's pretty important if you want to get attorney's fees. It's a budget. But it's an affidavit. So it's a sworn statement of how much money you make, all of your income sources, all of your debts, and all of your expenses. It is difficult to do because most of us don't know our finances well enough to know exactly what we spend on our cars. And you don't really just want to put your monthly payment. You want to factor in you know that you have to buy tires once a year or whatever. There are people who can help you. So if there's a lot on the line for you, it may be worth getting a little bit of assistance from a personal financial coach in order to get this type of a document done correctly. You also have to update it when things change. So, my friend, you get a raise, you got to do a new AFI. If you don't, you end up like my poor client who had to overpay for his child support. You can modify, but remember, modification is based on changed circumstances. So if you were making more at the time of when the order went in against you, you can't go back and modify against those circumstances. Does that make sense what I just said or not?
No.
Okay, yeah, it didn't. So we'll go back to my client who is overpaying in child support because we had evidence to show that mom's income was much higher than it was because of the way that she was hiding rental income. And he failed to disclose his raise, so the judge said, I'm using these numbers. He can't go back and say, I want to modify based on changed circumstances. Mom makes more money because mom made more money at the time. It's not a change in circumstance. So it really can hurt you long term. It's not an easy do-over. Better, right?
Yes.
If you can't get the information that you need, then we have these tools that we talked about. Interrogatories are written questions that are served on the other party. They have 40 days to respond, and their answers are treated as testimony. So you get to lock in that testimony. There are uniform interrogatories, which are really useful. They're uniform meaning pre-selected, pre-written for you, and a lot of them are great questions. So if you're representing yourself, you can get those online. You can get them on the Access Legal website, which is our website for people who are doing it themselves. It's accesslegaldocs.com. You can get interrogatories. You can send them out yourself. You can make non-uniform interrogatories, which means you get to make up the questions that you need to ask that aren't already on the list. It's a great tool. Requests for documents is a little less specific than uniform interrogatories or non-uniform interrogatories, but it says, hey, there are these documents that are either not covered under Rule 49. Rule 49 are minimum disclosures. It doesn't mean it's the only information you can get. It doesn't mean it's the only information that you want to have, okay? It's just minimum. Under these circumstances, we want this information shared. If there's other information that you need, and there very well may be, you need to use a request for production of documents. And you can also get that on the Access Legal website. You can list out exactly what you need for documents from the other party. They have, and these can be things too, or inspection. So let's say you need to get a house appraised and your ex is like, nope, you're not getting in. You can use your request for production of documents to inspect property or tangible things. Get into your safe and see what's there. You can even ask for, a computer, an old computer that you want to have imaged or whatnot. So these are powerful tools to really get information. All right, and you can do this and interrogatories. It doesn't have to be one or the other. You can use all of them. Now, you don't want to do more work than you have to. And you don't want to use these as harassment tools, because if you do, you will likely be labeled as unreasonable and pay the other party's fees. Okay, depositions are probably the most powerful discovery tool. And they're not appropriate under all circumstances, but a deposition is where you get to have the other party show up wherever you want, and you hire a court reporter, and they come and they take a transcript, and you're allowed to ask questions of the other party for up to 4 hours, and you can ask any questions you want, and they have to answer you. And you can do a video, or you can have just a typed transcript of what they say. This is great because you're going to know what the other party is going to say in court. That's very, very valuable. Or if the other party decides they want to change their mind, change their story in court, you have a record of sworn testimony from a deposition that says, hey, wait a second. You said during your deposition that you wanted a parenting plan that you wanted to move to Minnesota to be with your girlfriend. and now you're saying you want to move to Texas to be with your new girlfriend. that would be good information. You would want to use your deposition to show that this person was being unreasonable and fickle, and it's probably not a good idea to let him move with the kids to the girlfriend, don't you think? That would be convincing. It would probably. All right. Depositions are fun if you can work it out and it's appropriate in your case and you have information you want. You should consider doing it. All right, that's all for today. I know it was a super high level overview. So any questions specifically on that before we go to the questions that have come in over the week?
If you mentioned that if somebody doesn't disclose something, you have the different tools to access.
Right.
But how do you know maybe when it's time to go ask the judge as opposed to exhausting your avenue for, you know?
Great question. I should have talked about that. So, oh, you're taking my mouse away. It's clicking too much apparently.
No, I'm just putting it on you because you.
I did, but I want to be able to watch Facebook live with all my other friends. Can't do that?
I just am having the video going.
Got you. Okay. So, great question. This is when you file a motion to compel. Okay? A motion to compel allows you to ask the court to require someone to disclose something that they don't want to disclose. All right? So here's how that works. You send out your interrogatories. You want them to itemize where all of their safe deposit boxes are located and the contents of their safe deposit box. They don't want to answer that question. They don't want to answer it because they're pretty sure you know something, but they don't know what you know, so they don't know what they have to write down because, you know what I'm saying?
Yeah.
It has to be there. It has to match up or
They're
you're a
trying to do
liar.
Trying to do that.
So they don't want to answer. You send that nice letter. Hey, remember I sent you this interrogatory on January 1st and it's now March 2nd. You're past your 40 days. You have 2 weeks to get this to me or I'm filing a motion to compel. Then you have to wait your 2 weeks and you have to probably call up again before you file your motion to compel. Say, hey, just checking in. Are you going to get me this? Because before you file a motion to compel, you must show good faith efforts to get the information. Otherwise, judges don't like dealing with motions to compel. But at that point, let's say you still can't get this information. You file a motion to compel. The other side has the opportunity to respond to that. They have 10 days to respond after you file your motion. And then you may or may not get a hearing on the issue. Now, if you have to file a motion to compel to get the information that you need, the statute requires that the other person pay whatever costs were incurred for you to get that information. So your letter that you wrote, your motion to compel, your time on the phone, your court hearing costs, any costs associated with the motion to compel to get the evidence that he or she should have already given to you will be awarded to you.
So, like in a law firm, they keep invoices, but if you're representing yourself, then, do you need to be keeping some sort of a log so that you can show what costs you did incur? Like, what would be the best way of going about that?
And that is a fantastic question because you can only get attorney's fees if you're represented by an attorney.
So if you did hire an attorney to help with that portion,
then you're going to want to have those receipts of everything you paid. And yeah, definitely. And you can ask for other sanctions. You can ask for, specific amount of money or whatever it is that you would like. Maybe you really want the armoire and you guys are both fighting over the armoire. The judge decides, I'm going to give the armoire to the person who didn't hide money or, who didn't make me deal with a motion to compel that I didn't want to deal with. That's absolutely possible.
Okay, can I ask another?
Yes.
Okay, so if you go out of your way to ask for all of this information, but you understand that the judge isn't gonna like the motion to compel. Can you bring that up at the hearing
Okay,
as opposed to the, so that you aren't annoying the judge, but
right. So that's a great question. So what Caitlin is asking is, let's say you can't get the information you need. You write your letters, but you don't want to file a motion to compel. Maybe it's not worth it. Maybe it's not worth the money. Can you bring it up at trial? You absolutely can. Although the judge is more annoyed if you've annoyed him or her along the way by reminding them several times that you haven't gotten the information you want. It's more effective if your goal is that you want the judge to know that this person isn't following the rules and that you've done everything in your power, then you probably need to file some stuff and put the judge on notice that it's happening. If you don't care, let's say you're asking for information and you don't really care, you can make your case without it. It's not essential, so it's not worth the money. Then you can just wait until trial, bring it up in your pretrial statement, bring it up in testimony. But with that being said, there's usually limited time in front of a judge. So in Arizona, you are set for a specific period of time for an evidentiary hearing, and you have to get everything in during that time period. Now, when I say everything in, that means everything we talked about today. Any issues that have not been settled in your case get broken down into their sub-elements, and evidence must be offered on each element. You must do that within your allotted period of time, because that is the only information the judge can consider when giving his or her ruling. That's a massive challenge when you think about it. Really a massive challenge. So you really have to think long and hard about whether or not you want to spend that time talking about that he didn't follow the rules, giving you information. That's taking time away from telling the judge about why the school that you've chosen for your kids is more important than the local school by his house.
right.
Okay. So these are tough decisions. What other questions do we have?
Some of the questions that's been sent in over time are a little off topic.
That's okay. Yeah, no. Anything's open.
So we have some different questions about property, like what are your rights with property? How is it usually divided? Just kind of, it's a confusing topic.
Is it a specific question or no?
Well, it just says, what are my rights? For example, like how is property usually divided?
Okay. All right, that is a broad topic.
I know.
We're gonna do an entire hour on that. But in general, Arizona is a community property state. Any property and any debt that you accumulate while you're married is community property and will be divided equitably, which is most always equally. That doesn't mean that each piece of property is sliced in half, but it means each piece of property is thrown into the whole, and the whole pie is divided as close to equally as possible. I don't know if that's even an adequate question, answer.
I think that maybe that person's just going to need to wait till we get to that part.
Or send in more specific questions.
Mm.
Absolutely. Let me know what it is that you're wondering and we'll talk about it.
Let's see. How can I go about getting help preparing the forms in a divorce?
That's a fantastic question. There's a lot of resources. You can come to one of these seminars and ask questions and we'll walk through it. I was even thinking we may, if there's enough interest, we could have a seminar where we walk through some of the forms line by line and fill them out together. So let me know if that's something that would be helpful or useful to you. You can hire a paralegal to help you. You can hire an attorney to help you. You can go online and see what information there is. There's a ton of information on the Access Legal website about how to file and fill out these forms, but they can be confusing and they are individual, so it may be something where you have to get a little bit of help.
Okay. Can I move before the divorce is final? Or like, if I'm thinking about moving, is there a time that might fit best?
Are we moving out of state or are we moving?
Doesn't say.
It doesn't say. All right, so lovely people. The more specific you can be in your questions when you write them in, then the better we can speak about the information that is most relevant to your question. So let's take both scenarios. Can you move before your divorce is final? Let's say you want to move out of state. The answer is yes. Nothing is stopping you from moving out of state. If you've got kids, you can't move your kids out of state. The preliminary injunction goes into place. You can't take your kids out of state. It's actually even sort of risky to move right before you file. Now, I have a client right now who moved a good 6 months before she filed, and that's safer. Although the UCCJEA says that wherever the kids have lived for the last 6 months is the home state. So you can actually even change who has jurisdiction over your divorce, depending on when you move. So that's a complicated question. If you don't have kids, you can do whatever you want. You still have to come back for the court hearings, and you still have to participate fully in all the rules that we've talked about, but nobody can stop you from moving out of state. They can just stop you from taking your kids, which is kind of a big deal. Can you move across town? Sure, absolutely, no problem. Now, I've written a lot about this because it's expensive to have two households with the same amount of income that you had with one household. And it's really worth considering logistically what is best in your situation. Legally, there is nothing stopping you from moving out before your divorce is final. There's nothing wrong with it at all. And it's a perfectly legitimate option. For some people, it is absolutely the best option. But it's just worth really kind of practically considering, okay, well, where am I moving? Am I moving in with my mom? Because that won't cost me anything. Does my mom live near my kid's school? Because I probably can't move my kid's school. Am I going to stay with my friend? If I go stay with my friend in an apartment, do I have a place where my kids can come visit me? Or am I effectively leaving them at their home with the other spouse who's now going to use that to paint me as the bad guy who abandoned my family? These are all questions that you need to think through before you decide whether to move. If you're in a dangerous situation, don't think through anything, get out. Or go get an order of protection and get him out, or her, if she's the aggressor.
That happens.
It does. Actually, if there's an order of protection or violence, it's probably the easiest way to get somebody out of a place and get safe.
So you don't have to leave.
So you don't have to leave. Yeah. But a lot of times you'll have a couple that's just unhappy and there's no domestic violence, but they just don't want to live together anymore. And he wants the house and she wants the house. And I had this come up the other day where somebody was like, well, how do I get him out? Will a judge make him leave? Question is, I don't know. You say you want the house because what, you like it and you want to stay there with your kids. And he says he wants the house because he likes it and he wants to stay there with the kids. Is the judge going to choose who moves out? Probably not. So at that point, you're stuck with waiting until the divorce, and then what's the judge going to do at the end of the divorce? Well, one of the questions is going to be, who can afford it? Who can afford to refinance the property to buy out the other person's interest? Is there enough other property so that when we put that whole pie together, we can divide it? And let's say somebody takes the house with all the equity because somebody else takes whatever it may be, land or rental property or retirement or a business that offsets the value, and you can refinance it, then maybe that person would keep the house. So we kind of have to wait until it logistically makes the most sense to figure out who gets the house or just sell it. And with that, I want to talk for a little bit about selling a house. A lot of parents feel like they don't want to sell the marital home because their kids are comfy there, and they don't want the kids to experience more trauma and transition that comes with moving. It's legitimate. It's a legitimate concern, but it should be weighed against the other practical impacts of keeping the marital home. Many times when people have a marital home, they might have required both people to be working in order to afford that home, or it might be bigger, or the expenses might be more than they can handle. And women, I see, do this more than men, where women will really kind of emotionally, sorry to do that to you ladies, I love you, but women may be more emotionally attached to their home and more likely to say, I'm not leaving, even though it's financially not in their best interest. So they could downsize and have a lot more room in their budgets, maybe be responsible for a whole lot less yard. So you're weighing, the interests of your kids and the financial impact to you. But I just want to bring up one other point when it comes to the kids and their emotional impact. Sometimes it is easiest for the kids to start over into new houses so that they're not with mom at home and with dad at dad's house. Especially when mom goes to start dating. Now they're in their house that they grew up in, where mom and dad used to live together. It's painful that mom and dad broke up, and now mom's new boyfriend is hanging out around the Christmas tree. Like, sometimes that is psychologically worse than just saying, guys, here's our new lay. This is mom's house, this is dad's house. You have two houses. There are some benefits, especially if you can get beyond who gets to win and keep the kids in their home. If you can get beyond that to really thinking about how do we make this transition easiest on them long term, what I've seen is that sometimes the best thing you can possibly do is get rid of that marital home and everybody starts over fresh.
Is there any places where people could go and sort of vet what you've seen? Because I'm sure that you've seen it from more of like the watching families,
right,
being in your industry, as
right,
opposed to like, do you know of any studies that?
I don't. This is totally,
Sorry.
No, it's true. Like, if I was an expert witness, I would be disqualified. This is not, I don't know if anybody's studied this. It would be really interesting to talk to maybe counselors who work with divorced couples to see if their experience is the same as mine. I have talked to other divorce attorneys who seem to feel the same way, but it's mostly just based on what I see, and especially when you get unhealthy relationships with kids and one parent and parental alienation type situation, which almost always the parent who kept the house and kept the kid has kind of owned their castle and dug in their heels, and they've rewritten, or they've written a story that really damages the relationship between the children and that other parent. So, and I have seen enough families afterwards to know that that is the worst possible thing you can do. Mm-hmm. So starting over and getting a new house and downsizing and saving money is a good thing, and you value the relationship with your children and their other parent moving forward, it's something you should really strongly consider. Not best in all circumstances, and this doesn't happen in all circumstances. It's just seeds to be planted, because there is another option besides, I want to keep the house because that's what's best for my kids.
Yeah, you're just given lots of different things to evaluate if you're going to.
Right.
Yeah. Okay.
All right, we have just a couple of minutes left. Any other questions?
What if I disagree with the order that came down from the judge?
Yeah, this happens a lot. What if you disagree with the order that's come down from the judge? You have several options. None of them are fabulous. You can file to appeal. That's a separate process. You can appeal based on legal error only. This is not something we can talk about in 5 minutes, and it's absolutely something you should talk to an attorney about. You can file a motion to reconsider. Most of the time, this does not work. You can file a motion to amend a clerical error. Let's say that they got the kiddo's birthday wrong and it's going to impact when child support ends. You just file a motion to amend the clerical error and you can get that done. you can file a motion to set aside based on certain criteria that's set out in Rule 85. You can file for a new trial. Had that work once. There's not a, yeah. So let's say in that particular case, there was undivided property. There's just, oh my gosh, it was a complicated case. There were so many errors. And we ended up working it out through arbitration, which we'll talk about in our negotiation section. So the other thing is, if you're talking about kiddo issues, they are modifiable. They're modifiable after 12 months or 6 months if the other person is not following the decree. So let's say that the judge has ordered equal parenting time and you find yourself with the kids 90% of the time. After 6 months, you can file to modify, to have the order reflect reality and adjust child support. We can't do it immediately. All right, any other questions? Great. All right, well, thank you guys so much. And we will see you on the 3rd Tuesday of January.